Chief of Justice, Oliver Ellsworth, by Jonathan Garcia and Rayan Jathan. Oliver Ellsworth was born on April 29, 1745, in Windsor, Connecticut, to his parents, Captain David and Jemima Ellsworth, prosperous farmers who raised their kids as such. Ellsworth attended Yale in 1762, but later transferred to the College of New Jersey, later known as Princeton University, to study law in hopes of pursuing a career as a lawyer. Before becoming Chief of Justice, Ellsworth served as Senator of Connecticut from March 4, 1789 to March 8, 1796, where he helped lead many things such as the Judiciary Act of 1789, the Funding Act of 1790, and the Bank Bill of 1791. Ellsworth was nominated as Chief of Justice by George Washington on March 8, 1796, making him the third Chief of Justice of the United States. He served until December 15, 1800, where he resigned due to his own personal health issues. A landmark case was Ware v. Hilton. This issue involved the British that had claims against the Americans from contracts made before the Revolution and treaty provisions that required payments due to them. The justice ruled under Ellsworth that a treaty of the United States must override the law of any state. This was a landmark decision that was held for 2 centuries.
Our Supreme Court case is Hustler Magazine v. Falwell. The parties involved were Hustler Magazine, which is a monthly pornographic magazine published in the United States, Jerry Falwell, who is an American Southern Baptist pastor, a televangelist, and a conservative, and Terry Abrahamson, who was the writer for the parody, and Mike Salisbury, who is the artist. The case was argued on December 2, 1987, and decided February 24, 1988. Jerry Falwell was based in Lynchburg, Virginia, and Hustler Magazine, Gardena, California. At first, Jerry Falwell sued the magazine for the parody, but then Flint appealed to the Fourth Circuit, which is a federal court located in Richmond, Virginia, with jurisdiction over the district courts. But the Fourth Circuit was declined to rehear the case, so the U.S. Supreme Court granted Flint's request to hear the case. Hustler Magazine and Larry Flynt argued the First and 14th Amendment, which prohibits public figures from recovering damages for the emotional distress caused by parodies or satire of the public figure that a reasonable person would not have interpreted as factual. The case had such an impact that there was a film created in 1996 called The People vs. Larry Flynt, which was based on the case. After the movie, Falwell and Flynt began meeting in person to discuss philosophy. They visited colleges to publicly debate morality and the First Amendment, and eventually became friends. In an 8-0 court decision, the court ruled in favor of Hustler Magazine, holding that a parody ad published in the magazine depicting Jerry Falwell as an incestuous drunk was protected by free speech, considering that Jerry Falwell was a public figure and that the parody could not have been considered believable. Thank you for listening to our presentation, and we hope you all have a great rest of the day. God bless.